Hey, Brian Parker here with another exciting video. I don't usually focus on the same creditor or debt buyer, so I'm going to be using PRA today as an example of how these lawsuits are filed so recklessly that you have to scratch your head and wonder, did they even read these documents after the attorney who under oath has to sign something that he declares he has reviewed and it meets with all the good faith rationale to file a lawsuit against the debtor. As you go through this stuff, you got to scratch your head and go, what was the attorney thinking if he's putting his name on the line that is dotted? And what is PRA thinking? Well, what are they all thinking? That 8 to 9 out of these of every 10 lawsuits filed will be ignored, defaulted, or face an early settlement. So there's a recklessness there. But as I always say, we use this to your benefit and my client's benefit. And as always, this is hot off the presses, meaning I am presenting to you an actual lawsuit. Again, it's Portfolio Recovery Associates, but I'm using them as a template rather than focusing specifically on them. So I last week did a great video in that I'm giving you a free affidavit PDF checklist or a cheat sheet. I wish I'd called it that. And you just go down the cheat sheet as you tear apart the lawsuit and then figure out what they've done inappropriately, falsely, or just outright they've got the wrong person they're suing upon, or creditor, which is the case today. So let's check it out, man. So I always have show notes for you, and for you meaning I attach them to our membership video, so it helps you understand sometimes what I'm saying. Hopefully it does. So I'm not going to do that today. I'm going to do something unique in that I'm going to use the actual affidavit as my show notes. So I'm going to do what I do. I'm going to break down their lawsuit, break down their documents. As you always know, what's my mantra, my number one mantra? Hearing it? Hello? Beulah? That's right. Use their own documents against them. And that's what we're going to do today. So let's put up page 2 of their lawsuit. So I've torn down the lawsuit, and this is what I want you to do. Just by the numbers if you want to go my way. So page 2, Shazam. And again, if you look at the top, you can see paragraph 6, Comenity Capital Bank. Seems okay right now. Number 7, the plaintiff, through its assigner, blah, 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 has received this debt and defendant's a bad person. And you can see again that I've circled the word account. And if you go lower, you can see account, 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 because they just don't want to say debt, because the debt is actually not part of the lawsuit they're filing against you. And that's our securitization of it all, which we'll see a little bit of today. So they say Comenity Capital Bank, see the attached bill of sale. So let's go to the bill of sale. We go to the bill of sale, Shazam, and we're going to put the bill of sale right next to the page 2. So if we look at that, it says bill of sale, PRA PLCC, PayPal Fresh, May 2023, whatever. So look right below that, and I'm not going to say this, but and for my podcast people, it's a rather long address that ends in .xml. I think that's the .gz IP. It's significant for 2 reasons. Number 1, the body of the bill of sale does not have the word Comenity Capital Bank. Didn't they just say that, hey, this is from Comenity Capital Bank? Just look at the bill of sale. So I'll give you a minute to look to see if the words Comenity Capital Bank appear here in this bill of sale that we were told to refer to as proof that plaintiff owns this debt. Waiting. Okay, it's not going to be there. So it is a Synchrony Bank debt. And you will see that's kind of weird compared to what they're saying is owed and to whom and as to why. And you can also see that long list of, as we've seen before, Lynn Fisher signing for Synchrony Bank, RFS Holding, Synchrony Card Funding, Retail Finance Credit Services, but not a Comenity in the house. So first of all, Lynn Fisher does not have the authority to sign, whoever she is, for this conglomerate of assignees and assignors. More important to you and your affidavit that you're creating. So I'm showing you the affidavit I create by the numbers as I tear it down. Where's the assignments allowing these companies to pass this debt off to somebody? So it does identify in the bottom, let's keep the bill of sale up. On the bottom, it says the accounts, again, no debts, are set forth in the notification files as defined in the agreement. All these bill of sales are conditioned upon a forward flow agreement. This one's called forward flow accounts purchase agreement, which you'll never see. And again, as I've said in the past, if you get into a sticky situation where you feel like you're losing, do a discovery request for the forward flow agreement. They do not want you seeing that. They'll put up a fight, but eventually the judge is going to go, well, it's right in your bill of sale. You got to give it to the guy. So look at the notification. We'll just call it the data file right now, which is what they call it also. It's a sale file. So let me put up the sale file, the first page, and this one starts at the top, asterisk, 3568, Shazam. And now what I'd like you to do is, on the one side of this data sale file, I want to put up the bill of sale, just the first paragraph, with the PRA SFFLPRs on that address. And then below that, I want to put just the top letters, the top 3 lines, if we can't see it, but I want to focus in on this, the sale file. Look at those two. They do not end, just, for example, if you were writing me brianparker.com at collectionstopper.com, you wouldn't put .net on the end, you'd put .com. That's the same thing here. They've completely forgot or haven't GZIP, which is required for them to legally say the actual file in the bill of sale, which doesn't talk about Comenity, is in the sale file. So what they're trying to do, and think about Green versus PRA or PRA versus Green, the court talked in terms of, if you're going to have an extra piece of paper, instead of writing your assignment, it's got to be certified, it's got to match up, it's got to have the account number. It's all BS. You can't have an extra piece of paper on an assignment. But if you must, it's got to be certified and not be hearsay. But it's also going to be consistent. So here they do not have what's called the data extension on the sale file compared to the data extension they refer to in the bill of sale, and the bill of sale is garbage anyway. So in my affidavit, I'm up to number 7 in my affidavit. Before I go any further, let me just put up page 1 of my affidavit, Shazam, and this is the counter affidavit that I filed with this lawsuit defense. On my membership website, collectionstoppersolutions.com, you'll see the actual lawsuit, which will be attached to my actual answer, breaking down, tearing apart what I'm doing now. Also the counter affidavit in Word, my answer for you to review and use in your state in Word. And you will also see, if I can find it, an email I sent to the other side. Basically, it should have been RE. Are you kidding me? So check that out, and you can use that when you're in your defense. Not just against PRA, but all these companies. So I talk in my affidavit number 7. Let's put number 7 up there, Shazam. And you can see I've reviewed the sale files and they don't match up. And you have to match up to be consistent with what you're saying. And again, the bill of sale smells, it doesn't even have Comenity in it when they're saying in their own lawsuit, this is a Comenity Capital Bank assignment. I also go at number 9, of my Counter Affidavit, Shazam, you can see I lay it out for the court. I don't just go, here, you check it out. Be a good defendant. And I say, give the court the ability to see what you see. Make it easy for them, and they will make it easy for you. Keep that in your brain. Make it easy for the court. They'll make it a lot easier for you. Because of the garbage that the courts see all day long, somebody that breaks stuff down and is really clear about their defense. Now, someone said, hey, Parker, you don't want to give away the store and show them everything. That's correct, but there's a time and a place. Here, you want this out of your hair immediately, so you go all in on your defense. As I say, that counter affidavit you're not a denial defendant. You're a good explanation of my defense defendant. And here, you've said, who are all these companies that are being assigned the debt without any proof? So I say at number 9, there are several entities in the bill of sale, all without any assignment to and from each other. And further, this is supposedly number 10, a synchrony bank debt, yet the affidavit attached to the lawsuit states the original credit is a comenity. So let's put up the affidavit, Shazam. This is a beaut. First of all, paragraph 11 of their lawsuit says, if you don't believe us, just look at the affidavit. So let's look at the affidavit. And if you look at paragraph 2, let's focus on paragraph 2 of the affidavit, Shazam. So I want to put up the actual affidavit, and to the side for the folks viewing, paragraph number 2, Shazam. And you can see they're saying the original creditor is Comenity Capital Bank PayPal Credit. Now what they do is they throw in, and listen to this, and those records transferred to account assignee from Synchrony Bank. Who's the account assignee? Does it say? I don't see it, but that doesn't stop them from going forward with this. But there has to be an assignment. If Synchrony Bank is in this, as the affidavit affiant says so, Comenity Bank has to assign to it Synchrony Bank if we're to believe this bill of sale. But there's nothing. There's no assignment to Synchrony. So I believe they make these affidavits 1,000 times a day. Someone threw in the Comenity Bank and it just nobody pays attention anymore. They're in their phones. So that paragraph 2, guess what? Ends up at number 10 in my affidavit. Look at my counter affidavit, Shazam. You use their records against them. And there it is. I'm telling the court, this makes no sense. Why is a synchrony bill of sale in this case? And now we come in on number 11, show number 11 on the counter affidavit. The affidavit, which is signed under oath on October 2023, refers to me as defendant and Comenity as plaintiff. And I say Comenity wink wink because we really don't know who the plaintiff is really. Even though the court lawsuit was not filed until 5 months later, April 1, April Fool's Day. So under the state statute of the state I was filing this in Michigan, you've got to do it within 10 days. The affidavit must be fresh and within 10 days before the lawsuit's filed. And there are different states with different variations on that theme, but I guarantee you 5 months, you can't have an affidavit supporting something 5 months later. By the way, my point as always, and as I put up paragraph 11, you can see that for the court, I break it down even further. You can see, here's where they said October 20th, this is the truth under oath, and yet here's the summons, which says April 1st. And I say, literally, the court can see from the lawsuit there's no paperwork or any documents showing they have a right to sue me on the debt amount. And this is in a secured trust. How do we know that? Because at number 30, so let's put up number 12 and number 13 of the account stated statute, Shazam. At number 13, because the word debt is not used in the lawsuit and everything is based upon an account. For example, paragraph 6 and 7 that are stating an account was transferred to PRA from Comenity, though the bill of sale says Synchrony. So you always keep letting the court know and repeat, so the court will get a flavor of this. I used to try a lot of cases. We haven't in a while. I got one coming up though. And I would just keep repeating the same again, and I would look over to a juror, and as I'm saying it, she'd be saying it with me because I'd said it so many times. You gotta believe they go back to the deliberation room and repeat, you know? So you're repeating it for what's called in the business, the trier of fact. So a judge is a trier of fact. If you've done a jury demand, the jury is a trier of fact. As I'm doing this, I'm thinking of a good video about juries and judges, and we'll have one later. But you can see that this thing is a mess, and if you look at 6 and 7, let me put 6 and 7 paragraph of the lawsuit next to 11, 12 and 13, so you can see what I do. Shazam. And I'm just repeating what they're saying. Isn't that great? They've done most of the work. I'm going to make a statement to you. I think 80% of the work you need to do comes from their efforts. I think that's pretty true because you just use their documents against them and you'll do just fine. So then I go forward and say an account is number 14, Counter Affidavit, paragraph 14, an account is not a debt. I don't owe an account, especially with the wrong original creditor. So these are all things that are true that you sign off on. If you look at my answer, so if you look at the 3rd page of my answer, guess what? Up pops, look at the 3rd page of my answer, Shazam. And then next to that, put the 4th page of my answer, Shazam. And if we can, if the technology allows, the 5th page of my answer, which will say PRA Affidavits, PLCC, Payfresh. Boom, if we can put all 3 pages up there. What's my point? I just showed you what's in your affidavit. The affidavit has now written the answer for you, and it pops right into your what's called the preliminary statement. And everything that great work you just did on the affidavit, and that was my point from reading the affidavit for you today. So a lot of times, if not all of them, is you write the counter affidavit first, you just wrote the answer, and again, that's repeat, repeat, repeat for the court. They'll get used to that. And in my answer, I lay down all the pleadings that are just bogus right in the answer. And then you deny, and you look at every question as a purposeful denial on your part, because if you're sued upon a premise that is false, no matter what they say, it's all false. If the premise is this is a community capital bank with no proof, and it's clearly they screwed up, they even swore to it under oath, you can deny everything because of the false premise that they're acting upon. But again, we are not denial attorneys. We are explain the defendant's position attorneys. And that affidavit carries through to your, I'd say carry it through to your preliminary statement. Sometimes you'll look at my stuff and see in an answer, I'll go, no, that's not true, because on paragraph 6 they said this. That's probably the 3rd time I've said that. Again, we're pounding that in the court's head. Okay, so the last thing I want to show you today is, briefly, we found out they've cited the wrong, original creditor. The affiant has said, no, it's the right creditor, because we said so. Nothing says that. There's a couple of missing assignments. There's a person signing for 5 entities without any authority. Again, just look through Green versus PRA, and the court talks about you must have authority to sign for something. Who the heck just comes along and signs it? But more importantly, that assignment must have the account number, and it must have your name specific to you inside every assignment. And again, those signatures that were signed under the bill of sale, none of them have any proof of why they own the debt and where is Comenity. So, and to swear about all this under oath and to not mention any of the entities. And also, we looked at the sale file where the data extension is not the same as the one promised. There's clearly someone just schlockily put stuff together. And had this been defaulted, my client would have to pay. Fortunately, they got a hold of me, and I'm fortunate they got a hold of me. Oh, I didn't screw that up. Now, let me put up lastly the email I sent to PRA's attorneys. Shazam. And I say exactly what I just said. Your lawsuit claims to have Community Bank as the original creditor, but your bill of sale relies upon states it is Synchrony Bank. Also, the data extension on the bill of sale does not have the same data extension on the data file. The data file mentions Synchrony Bank, but no mention of Comenity. Your affidavit says Community Bank with confusing language, throws in a mention of Synchrony, but again, no assignment from Comenity. It's signed under oath. You called my client defendant and plaintiff. That is not possible 5 months before the lawsuit creates a plaintiff and a defendant. It's a mess with many entities signing off on the bill of sale. So I'm rather honest and bold and forthright. Here's where I'm coming from. So I say, I seek a mutual walkaway on this by May 13th, or I have to file a counterclaim on a small amount, debt by a case. Please advise soon. They do not want to get into me with a counterclaim when they've already, again, it's all about the original premise, when clearly they screwed up. I'll say the attorneys aren't bad guys over at Weber and Olsey. Maybe they're too busy, or they're thinking about the 9 out of 10 odds and making a run for it. But I keep popping up, and so will your intelligent knowledge of this stuff, hopefully using this stuff. So let's go get them. Again, this is a PRA lawsuit, but it can be applied anywhere to schlocky, false misrepresentations of claims. If you just want to follow one thing I tell you, and that's my number one, what's my mantra? Tick tock, tick tock. Use their documents against them. It is 80% of your defense. They're doing all the work for you. You do the affidavit, it just did the answer for you. By the way, if this goes on, which is not gonna, and we're looking at summary motions, the affidavit will give you what's called a material issue of disputed fact, depending on what state you're in. You're going to lose a summary motion unless you can produce a disputed but material dispute about the facts. And this more than does it. A good attorney will, on the other side, will recognize that and settle this, hopefully by May 13th. All right, if you like this, love this, subscribe to this. We can keep doing this, helping you. Go to collectionstoppersolutions.com. I think there's about 130 videos on there of all kinds, of all debt collectors, of all creditors, and I keep adding to it. This week I'm going to do a Barclays Bank. I just really don't have a Barclays Bank on there, so I'll do 2 for the price of 1. I'll do 2 Barclays Bank defenses from 2 different attorneys. It's a creditor defense, so the nuances are a little more, there's a little bit more work. Securitization comes in, but securitization is everything. How do I know that? Quickly, look at the bill of sale. And what do you see at the bill of sale? Well, first of all, you don't have an account. You have, you don't have a debt, you have an account. And more importantly, look at the names of those companies that are signing off. They are trusts. And what are they doing? Why is the debt so beaten up and fragmented like that? Because all these companies are making money from it, and now the debt collector is trying to get more money for PRA when this debt has been paid off already to the original creditor, and we're just not sure if it was paid to Comenity or Synchrony. Act accordingly, use their documents against them, like, love, subscribe, and let's rock and roll. Thank you very much for your